In ancient Babylon, a man who stole from a temple could be burned alive. In Rome, a slave who killed his master might be crucified. But these punishments were not random acts of cruelty. They were part of sophisticated legal systems designed to maintain order, project power, and reflect deeply held beliefs about justice. How did ancient civilizations punish criminals, and what can those punishments teach us about their societies? Punishment in the ancient world served multiple purposes. Retribution, deterrence, the Code of Hammurabi, inscribed on a 7-foot stone stele around 1754 BCE, is one of the earliest and most complete written legal codes. It contains 282 laws covering everything from trade to family matters to criminal justice. The code is famous for its principle of lex talionis, or an eye for an eye, but it also prescribed specific punishments for different crimes and social classes. For example, if a builder constructed a house that collapsed and killed the owner, the builder would be put to death. But if the owner's son died, the builder's son would be executed. In ancient Greece, punishment was often a public affair. The philosopher Plato argued that punishment should reform the criminal, not just inflict pain. But in practice, Greek city-states used exile, fines, and even death. In Athens, the death penalty was carried out by hemlock poisoning, as famously suffered by Socrates. Another common punishment was ostracism, where citizens could vote to exile a person for 10 years. This was not for crimes, but to remove someone considered too powerful or dangerous to the state. Roman law was highly developed and influenced many later legal systems. Punishments ranged from fines and confiscation of property to hard labor in mines, exile, and various forms of execution. Crucifixion was reserved for slaves and the worst criminals. Roman citizens could not be crucified. They were entitled to a more honorable death, such as beheading. The Romans also used damnatio ad bestias, where condemned prisoners were thrown to wild animals in the arena for public entertainment. This served both as punishment and as a spectacle to reinforce the power of the state. Excessive punishment and maintain social order. For example, if a builder constructed a house that collapsed and killed the owner, the builder would be put to death. But if the collapse only killed the owner's son, then the builder's son would be executed instead. This was not about personal guilt, but about restoring balance between families. The code also protected the weak. It set minimum wages, regulated medical fees, and punished false accusations. It was a system designed to create predictability in a world where justice could otherwise be arbitrary. But the Code of Hammurabi was not unique. Across the ancient world, other civilizations developed their own systems of justice. In ancient China, the legalist school of thought emphasized strict laws and harsh punishments to maintain order. The Qin dynasty, which unified China in 221 BCE, implemented a comprehensive legal code that punished even minor offenses severely. Yet alongside this, Confucian ideals promoted moral education and the idea that a ruler should govern by virtue, not just by fear. These two philosophies, in ancient Greece, the concept of justice took a different turn. The city-state of Athens developed a system of trial by jury, where citizens would listen to arguments and vote on guilt or innocence. This was a radical departure from the idea of a single ruler or priest deciding fate. The philosopher Socrates famously questioned the very nature of justice, arguing that it was not simply about following laws, but about living a virtuous life. His trial and execution in 399 BCE became a symbol of the tension between individual conscience and state authority. The Greek approach laid the groundwork for Western legal traditions, including the idea of a fair trial. Meanwhile, in ancient India, the concept of justice was deeply intertwined with religion and the caste system. The laws of Manu, composed around 200 BCE to 200 CE, provided a comprehensive code of conduct that varied according to one's social class. Punishments were often harsher for lower castes, reflecting a belief in cosmic order or dharma. Yet the same texts also emphasized mercy, nonviolence, and the idea that the king should protect all subjects. This blend of strict hierarchy and moral duty created a unique legal tradition that would influence South Asia for centuries. Blood feuds by ensuring that punishment matched the crime exactly. Hammurabi's code is often misunderstood as purely harsh. In fact, it included fines and compensation for many crimes. For example, stealing from a temple or palace could result in death, but stealing from a private citizen might only require repayment. The code also distinguished between social classes. A noble who injured a commoner paid a fine, while a commoner who injured a noble could face the same injury. This principle of an eye for an eye was applied literally only between equals. If a noble destroyed the eye of another noble, his own eye would be destroyed. But if a noble destroyed the eye of a commoner, he simply paid a fine. This class-based justice system was revolutionary for its time, establishing a written standard that applied to everyone, even the king. The code was displayed publicly on a stone stele so that all citizens could know the laws. This transparency reduced the power of judges to act arbitrarily. The stele itself was a work of art. At the top, a relief shows Hammurabi standing before Shamash, the sun god and god of justice. Shamash is seated on a throne, handing Hammurabi a rod and ring, symbols of kingship and justice. This image reinforced the idea that the king's authority came from the gods. The laws were inscribed below in cuneiform script. The stele was originally placed in the temple of Marduk in Babylon, but was later taken as war booty by the Elamites and eventually discovered in 1901. Today, the original stele resides in the Louvre Museum in Paris. It stands over 2 meters tall and is made of black diorite. Hammurabi's code influenced later legal systems, including biblical law and Roman law. Its legacy is a testament to the human desire for order and justice. The code reminds us that even in ancient times, people sought to create a society where rules were written down, punishments were known, and justice was, at least in theory, accessible to. Class-based justice was typical of ancient Mesopotamia. Punishments could be creative. A son who struck his father might have his hand cut off. A builder whose poorly constructed house collapsed and killed the owner could be executed. The code was displayed publicly in temples, so everyone knew the laws. This transparency was revolutionary. In ancient Egypt, the concept of mad, order, truth, and justice was central. The pharaoh was the ultimate judge, but local courts handled most cases. Punishments could include fines, beatings, or forced labor. For serious crimes like tomb robbery, the punishment could be death. But Egypt also had a system of appeals. A convicted person could petition the vizier for a retrial. This shows that even ancient legal systems valued fairness. Meanwhile, in ancient China, legalism took a different approach. The philosopher Han Fei argued that strict laws and harsh punishments were necessary to maintain order. Under the Qin dynasty, laws were applied uniformly, but penalties were severe. Even minor offenses could lead to mutilation or death. The goal was to deter crime through fear. Fines, beatings, mutilation, exile, or forced labor. Theft from a temple or tomb was considered a crime against the gods and often punished by death. Interestingly, there is evidence of a legal system that allowed appeals. A papyrus from the New Kingdom describes a tomb robbery trial where the accused were beaten to extract confessions, but they also had the right to speak in their defense. Egypt's punishment system was less codified than Mesopotamia's, but it was still governed by the principle of mad or cosmic order, which emphasized truth, balance, and just. Punishments could also be creative. A corrupt official might be branded, a tax evader could be forced to work in the mines, and those who insulted the pharaoh could have their noses cut off. By tradition and the principle of maintaining cosmic balance, ancient Greece, particularly Athens, developed a more participatory legal system. Citizens could bring cases to court, and juries of hundreds of citizens decided verdicts. Punishments ranged from fines and exile to death. The death penalty was often carried out by hemlock poisoning, most famously for Socrates. But exile was a common punishment for political crimes, as it removed the offender without killing them. Ostracism allowed citizens to vote to threatening politician for 10 years. This system reflected the Greek belief that law should be transparent and decided by the community. However, it was far from democratic by modern standards. Women, slaves, and foreigners had no rights. The Roman Republic later built on Greek ideas but added a more structured legal code. The 12 Tables, created around 450 BCE, were Rome's first written laws, displayed in the Forum for all to see. They covered property, family, and crime, and established that ignorance of the law was no excuse. Roman law emphasized the authority of the state, but also introduced concepts like innocent until. Roman law became the foundation for many later legal systems in Europe. After the fall of the Western Roman Empire, law in Europe fragmented. Local customs and feudal lords held power. But in the 12th century, the rediscovery of the Corpus Juris Civilis, a collection of Roman law compiled under Emperor Justinian, sparked a revival. Universities in Bologna and elsewhere began teaching Roman law, and it influenced canon law of the church and the legal codes of emerging kingdoms. This period also saw the development of common law in England, which relied on precedent and judges' decisions rather than a written code. The Magna Carta of 1215 was a landmark document that limited the king's power and established that everyone. The Enlightenment of the 17th and 18th centuries brought new ideas about natural rights and the social contract. Philosophers like John Locke argued that governments derive their power from the consent of the governed, and that people have inherent rights to life, liberty, and property. These ideas directly influenced the American Declaration of Independence and the U.S. Constitution, which established a system of checks and balances and an independent judiciary. The French Revolution also produced the Declaration of the Rights of Man and of the Citizen, asserting liberty, equality, and fraternity. Modern legal systems around the world now blend elements of Roman law, common law, and Enlightenment principles. For slaves, punishments were harsher. They could be beaten, branded, or executed. In Sparta, the state was even more controlling. Weak or deformed infants were left to die, and adult men who failed to meet military standards could be publicly shamed. Punishment in Greece was deeply tied to citizenship. Full citizens had rights that non-citizens and slaves did not. Roman law evolved from the 12 Tables, around 450 BCE, to a complex system under the Empire. Punishments were graded by social status. Honestiers, upper class, faced fines or exile, while humiliers, lower class, could be beaten, crucified, or thrown to wild beasts. The Roman legal system emphasized evidence and procedure, but also allowed for brutal public executions. Crucifixion was reserved for slaves, rebels, and the worst criminals. It was designed to be a slow, humiliating death that served as a deterrent. Gladiatorial games, however, were not primarily punishments. Most gladiators were volunteers seeking fame. They fought for glory, prize money, and the adoration of the crowd. The best could earn their freedom and become celebrities. And fortune. Only certain condemned criminals, Noxii, were forced into the arena without training, often to be killed in dramatic reenactments of myths. The Roman state also used damnatio memoriae, erasing a person's name and image from records, as a punishment for treason. In ancient China, punishment was influenced by two competing philosophies. Confucianism emphasized moral education and leniency, while legalism advocated strict laws and harsh punishments. The Qin dynasty, 221–206 BCE, used legalist principles. Even minor offenses could result in mutilation or. The Tang Code of 624 CE was a monumental legal achievement, balancing Confucian ideals of reform with harsh punishments. It became the model for East Asian legal systems, influencing Japan, Korea, and Vietnam for centuries. Punishments under the Tang Code included beating with a bamboo stick, penal servitude, exile, and death. The death penalty was often carried out by strangulation or decapitation, but the emperor had to approve all executions, reflecting a centralization. Confucian ideals promoted the idea that punishment should be reformative, not just retributive. The Tang Code included provisions for reducing sentences based on good behavior and for allowing criminals to redeem themselves through labor or payment. In practice, the system was often harsh, especially for those who challenged the state. Political dissenters faced severe punishment, including execution and the enslavement of their families. The ideal of reform often gave way to the reality of control. Death for murder, kidnapping, and striking a parent. The law demanded an eye for an eye, but also provided cities of refuge for accidental killers. In ancient China, the legalist school advocated harsh punishments to maintain order. The Qin dynasty used mutilation, forced labor, and execution for minor offenses. Yet the Han dynasty later softened these laws, emphasizing moral education over punishment. The Romans developed a sophisticated legal system that influenced much of the world. The 12 Tables, inscribed around 450 BCE, were the foundation of Roman law. They covered property, family, and crime. Punishments included fines, exile, and death. Crucifixion was reserved for slaves and rebels. Roman law also introduced the concept of innocent until proven guilty, a principle that survives today. In medieval Europe, justice was often brutal and public. Trials by ordeal, such as holding a hot iron, were believed to reveal guilt through divine intervention. Punishments included beheading, burning at the stake, and drawing and quartering. The stocks and pillory were used for public humiliation. Despite the harshness, the concept of a fair trial began to emerge, with juries deciding guilt in England. The Enlightenment brought a shift towards more humane punishment. Thinkers like Cesare Beccaria argued against torture and the death penalty. In his 1764 book on crimes and punishments, he proposed that punishment should be proportional and deterrent, not vengeful. This led to reforms across Europe and America. Prisons replaced corporal punishment, and the idea of rehabilitation gained ground, shaping modern justice systems. Offenses like murder, adultery, and idolatry, but also required multiple witnesses for conviction. The principle of an eye for an eye, again, emphasized proportionality. These diverse systems show that while methods varied, the underlying goals of maintaining order and reflecting cultural values were universal. Public executions were common across ancient civilizations. They served as theater, reinforcing state power and deterring crime. In Rome, criminals were sometimes crucified along major roads so everyone could see. In China, in public marketplaces, often by beheading, as a warning to others. The methods were brutal, but they were carefully chosen to maximize fear and control. In some cultures, the body was left on display for days, a grim reminder of the consequences. These practices, however horrifying to modern sensibilities, were integral to the social order of their time. They remind us that justice is not a fixed concept, but one that evolves with society. The journey from ancient codes to modern law is a story of gradual change, driven by philosophy, religion, and the relentless pursuit of a more just world. The crowd's presence was essential. They were witnesses to justice. But public punishment also had a dark side. It could become entertainment. The Roman arena turned death into a... Yet some ancient thinkers, like the Greek philosopher Plato, argued that punishment should reform the offender, not just terrify the public. This tension between retribution and rehabilitation persists. The legal systems of ancient civilizations laid the groundwork for modern law. The concept of written law, proportionality, the idea that laws apply equally to all citizens. These principles, born in antiquity, continue to shape our understanding of justice today. Even human rights can be traced back to these early codes. Hammurabi's influence can be seen in the principle that laws should be known and applied equally. Roman law shaped European legal traditions. The Tang Code influenced Japan, Korea, and Vietnam. While ancient punishments often seem brutal, they were part of a continuous effort to create order out of chaos. Understanding them helps us appreciate how far we have come, and how some questions about justice remain unanswered. Cuneiform tablets of Babylon to the marble halls of Rome, ancient punishments were more than simple brutality. They were expressions of a society's deepest values, its view of order, its hierarchy, and its concept of justice. The next time you hear about an ancient punishment, remember that it was part of a complex system that tried, often imperfectly, to balance the needs of the community with the rights of the individual. And that balance is still something we strive for today. From ancient codes to modern courts, the quest for justice continues.